we begin in our roles, I wanted to say that the problem that we're going to be using for the next hour was sent to all attendees on Monday, Monday evening, 11 o'clock Moscow time, sent out at 4 p.m. New York time. It may have gone into your spam folders. It went into my spam folder. And in the event that you haven't seen it yet, I'm going to just take a couple of minutes to give you the problem that we'll be using today, and will also be used tomorrow for the simulated cross-examination of evaluation experts. There's a different tribunal tomorrow, but it's the same problem. George Berman will be the sole arbitrator tomorrow. So in our case, the claimant is LearnFast, a UK company, which is in the business of operating English language premium tuition schools in Europe. LearnFast obtained a license from the government of Kalia, which is our fictitious former Soviet republic that has a legal system identical to that of Russia's. So LearnFast, the claimant, had a license to operate its English language high tuition independent school in Kalia. It made its investment, and then the government withdrew the license and required the LearnFast to operate with the same obligations and structures as Kalia government schools, which in Kalia's view made their further operation not possible, and eventually the local entity went into bankruptcy. And this case was brought under the Kalia UK investment treaty, bilateral investment treaty. Our case is under the UNCITRAL rules, and it's cited in London. The hearings had been scheduled for some time, the merits hearings, for 2 weeks, to begin on the 16th of November, in 2 months' time. And the tribunal has asked the parties to get together for this pre-hearing conference to talk about whether the matter should be postponed, the hearing should be postponed, or whether we should go forward virtually on the scheduled dates, and if so, how we go forward on those dates. I guess I should also say that Ms. Van Hoff, maybe I did say it, was appointed by the claimant, and Ms. Paisley by the respondent. Each side has 4 witnesses. For the claimant, 3 of their witnesses are in London, and 1 is in Kaiton City, which is the capital of Kalia. It's 3 time zones east of Moscow, Kaiton City, capital of Kalia. For the respondent, 3 of its witnesses are in Kaiton City, but 1 of its witnesses, its valuation expert, is in Singapore. The other thing to say at the outset is that we invite attendees to participate through the chat room. You can send notes, as we do in hearings, to either counsel or the tribunal. You can be a tribunal secretary. We'll monitor the chat room, and perhaps we'll have some time at the end of the simulation to talk about things raised in the chat room that we haven't addressed during the 1 hour that we have. So with that introduction, we'll go back into roles, and we're on the record now. So I invite and welcome everyone here. My name is Grant Tanessian. You have my colleagues, Ms. Van Hoff and Ms. Paisley, and we have the counsel here we see for both claimant and respondent. We see respondent's counsel in an unfamiliar venue, and perhaps we'll hear more about that. And why don't we get right to it? So, counsel, we've said that we wish your views as to whether we should go forward in 2 months' time, and if so, how we go forward at that time. So we'll hear first from the claimant, Mr. De Cruz.
Thank you, sir. LearnFast's position is that the merits hearing should proceed as scheduled on the 16th of November, but remotely. The US, Belgium, Russia, and Kalia are all currently on the UK quarantine list, and that is likely to be the case for the foreseeable future. Unfortunately, that means that an in-person hearing in London cannot realistically take place in November. However, adjourning to a date when everyone can be present in London in the same room is simply not feasible in the current circumstances, because nobody can say when that is going to be possible. The present situation in the UK in terms of travel movement and restrictions is extremely uncertain. The UK quarantine list is changing all the time, and new restrictions on gatherings were in fact imposed just last week. Now, we need to be clear about the consequence of not proceeding in November. It would mean either an indefinite adjournment or multiple adjournments until we can see a clearer picture. The delay that that would cause in the resolution of this dispute is going to be extremely significant, several months at the very least, and in reality, probably well over a year. And that is, one has to take into account that setting a new hearing date would also require coordinating the diaries of 8 witnesses, 2 sets of counsel, and 3 busy arbitrators, all of whom have already set aside a significant chunk of time in their diaries for a hearing currently scheduled in November. An adjournment which would result in this extent of delay would be inconsistent, entirely inconsistent with the due process requirement under Article 17.1 of the Answer Trial Rules that obligates the tribunal to conduct proceedings to avoid unnecessary delay and by means of efficient processes for resolving the dispute. Now, we shouldn't lose sight of the fact that when the parties incorporated the Answer Trial Rules into their agreement, they contracted to arbitrate any future dispute on the basis of the principles in Article 17.1. So our position is that it would be unfair to learn fast if we were now to depart from that contractually agreed approach. The tribunal will be well aware that this is a claim for damages relating to events that took place more than 4 years ago. The arbitration, this arbitration began more than 2 years ago. So LearnFast has already been kept out of its money unduly. Now, as to the suitability of a virtual hearing, the tribunal recognized this as a real possibility in April when it directed that we convene today to consider the viability of proceeding in person in November. It was apparent to everyone in April that an in-person hearing later this year might well not be possible because of what was then a developing COVID problem. So LearnFast's proposal to proceed virtually is nothing more than what everyone anticipated in April might be necessary. We're all aware that arbitration is supposed to be adaptable to the circumstances of the dispute, and that includes utilizing remote hearings where the participants cannot be present in the same location, which is the situation we find ourselves in today. A virtual hearing for a merits issue is now being adopted routinely in current arbitrations as the proportionate due process step in response to the current COVID problems. So this case, we say, is a paradigm one where a virtual hearing has become the only efficient process to adopt for resolving this dispute without unnecessary delay. And so for those reasons, LearnFast respectfully submits that proceeding remotely in November is now the only sensible way for the tribunal to progress this dispute, having regard to its obligations under Article 17.1. Those, sir, are my primary submissions.
Thank you, Mr. De Cruz. We'll hear now from Mr. Cavalli.
Thank you, Mr. President. First of all, I want to apologize for lack of formal appearance. As I mentioned before during the break, I would love to be in my office in Moscow and have my suit and nice tie and my team assisting me. But unfortunately, for the last 6 months, I'm locked in an island far from Russia. There's no flight connection, and I don't know when realistically I'll be able to join my team. I share concern of the claimant counsel that this case should proceed efficiently and expeditiously because we as a respondent also interested in finalizing this case as soon as possible. I also here agree that these days many tribunals are having their hearings virtually because there's no other way to have hearing in person. However, I submit to the tribunals that this particular case unfortunately cannot be had by video conference, mainly for 3 reasons. Apart from technical reasons, but I'll start with legal reasons. First of all, there were allegations of fraud made by the claimant with regard to respondent. And we take these allegations very seriously. And because there's allegation of fraud, we would ask the claimant counsels to bring the original of documents on which the fraud allegations are based, because we want to inspect these originals during the hearing. Virtual hearing does not allow us to review the document. And I'm afraid that without it, we cannot make real conclusion whether the documents were forged or not, whether fraud regulations are supported or not. And it has been consistent position of Russian courts, and I believe the Canadian courts as well, that party has a fundamental right to review written evidence in person, review originals, whether they indeed original or falsified copies. So without it, I don't think the tribunal would be able to make conclusion whether the originals are true or not, whether fraud allegation should be sustained or not. This is the first reason I'm really concerned about potential enforceability in Canada. The second reason is that there are many witnesses and experts to be heard in this case. And again, because this is a case involving fraud allegations, we want all of them to testify under oath and be criminally liable in case of perjury to the tribunal. In a situation when witnesses and experts are in different countries, I frankly cannot understand how they could testify under oath and subject to liability of which country they could be, and to have a risk of criminal liability. For us, it's a serious assurance that witnesses and experts will be telling only truth. The third reason, unfortunately, we are in a completely different situation with Mr. Cruz, because he is sitting in his office in London with his team. His witnesses are in London. I am sitting here in Ireland, even with, without notebook. I have only planchette with me. I mean, tablet and iPhone. My notebook is in Moscow. My team is in Moscow. Witnesses are somewhere else. So I cannot have access, the same access to witnesses and documents as counterparty has. It puts us in completely different position with regard to ability to present our cases. So I submit to this tribunal, yes, I realize that 6 months ago, we thought we might have virtual hearing, because at that time I was hoping that I'll be able to fly to Moscow, but now I understand I cannot. So this case is lasting for already, I don't know, more than 1 year. All events happened 3 or 4 years ago. It will not be a problem if you wait for another 2-3 months. Russia already announced new vaccine against COVID-19. So I hope situation will be resolved soon. So I kindly ask the tribunal not to have virtual hearing in November, but rather find a suitable date to meet in person somewhere in February or March.
Thank you, Mr. Cavalli. We may have some tribunal questions, but let's first ask Mr. De Cruz to respond.
Thank you, sir. Well, if I might just pick up on the last comment of my friend, I think to suggest that an adjournment would be no more than 2 or 3 months is frankly unrealistic. We're all aware of the current situation. The reality is that we're talking about a delay of much more than 2 or 3 months. As far as the authenticity of documents is concerned, I find that a surprising argument that the tribunal needs to be able to inspect it themselves directly in order to determine whether or not the document is authentic, in a situation where authenticity is put into issue. That is a matter which should be referred to a handwriting expert. And we would certainly be quite concerned if the tribunal took it upon themselves to opine on something which is really quite a technical issue. So the documents in question can and should be sent to a handwriting expert, either appointed by each party or a single joint expert. So that issue can be addressed through a virtual hearing. As far as perjury is concerned, the point is actually quite clear and should really give the respondent all the comfort that it requires. The lex arbitrae of this dispute is English law. And under English law, the tribunal has the power under section 38(5) of the English Arbitration Act to direct that witnesses and experts be examined on oath or through affirmation, and also to administer any necessary oath or take any necessary affirmation. As an adjunct to that, section 1 of the English Perjury Act of 1911 makes it an imprisonable offence to knowingly give false evidence under oath in judicial proceedings, and that includes arbitration. And thirdly, it matters not whether the witness or expert who gives evidence under oath does so from abroad. The Perjury Act applies as long as sworn evidence is given in the course and for the purpose of English arbitration. So there's no difficulty at all in the witnesses and experts in this case giving evidence from anywhere abroad for the purpose of this English arbitration. If they give false evidence in the arbitration, they can be prosecuted for perjury in the United Kingdom. So the perjury position is not affected by whether this hearing goes ahead virtually or in person. And I think the last point that my friend made was technical issues that he is facing. Well, in this modern age, it's very difficult to imagine that with 2 months' notice, Mr. Farley will be unable either to find a location with sufficient bandwidth or to find equipment that will provide the necessary bandwidth where he is now. In the current technological age that we are living in, that would be a remarkable situation. But even if there was any real concern about being able to access documents, being able to participate in the hearing from where Mr. Farley is, then contingency plans should be put in place now by the respondent for another member of Mr. Farley's very talented team in Moscow, already working on the case, to lead at the merits hearing if that proves to be necessary. Again, there is more than enough time for preparation in that regard. So, and it isn't the case, the last point I would make is it isn't the case that we, for the claimant, are all in London and able to operate from London for the purpose of this arbitration. One of our experts, the legal expert, is in Moscow, and one of our factual experts is in Kalia. So we face similar problems, but we are very confident that these issues can be addressed through a virtual hearing, and therefore that both parties can properly present their case at a virtual hearing in November, which is all that you, sir, and your colleagues need to be concerned about.
Thank you very much. Mr. Cavalli, briefly, please.
Briefly, sorry, I frankly didn't hear half of what Mr. Cruz said because internet line was really, really bad. This shows by itself that we might see a problem with the hearing because internet connection is really not good. And sorry, in this island, this is the best connection I could have. What I've heard that you said that there will be some members of my team. I'm really sorry. I have junior associates. They are very good in compiling the documents, but they cannot present this case. I've been in this case from the very beginning for 5 years. And my client could not find suitable counsel in 2 months. I think it's impossible.
Thank you very much. Let me ask my colleagues if they have any questions for counsel.
I don't know if Ms. Paisley wants to go first. I was wondering if we could explore some of the maybe more technical issues to get a sense for how much discussion the parties have already had about this, and whether we can make some progress before making any decisions by looking at some of the options. I mean, I would think as a starting point, it is true, at least in general, that some arrangement can be made. And I don't want to express a view, of course, on whether in this case we should proceed. That is for this tribunal subsequently to decide. But given the range of time zones that we're in, have the parties had any discussion about how many days, how many hours in the day we could sensibly get together? Because I'm very keen that if and when we decide to do a virtual hearing, that it's going to be workable. And I think I would appreciate some comments about timings, platform, and maybe hosting of the hearing. Because there are providers, third-party vendors, who make available facilities, both technical facilities, but also hearing room facilities, which might accommodate of the parties and people involved, even though they don't necessarily have to be in the same place. So some of the experts or witnesses could be in a particular hearing center, which need not necessarily be where their counsel or where the tribunal is, and it would still then potentially help to move along the hearing. So thoughts on hours, platform, and potentially hearing room providers to accommodate the hearing, that would be most helpful. Thank you.
I'm happy to address those points first, if that's convenient. So in terms of timing, I think that the main challenge that we face is the fact that our chairman is in not New York, but New York time zone, I think. And at the other extreme, we have the respondent's expert who is in Singapore, and factual witnesses for both the respondent and the claimant who are in Kenya. Now, the difference between the chairman and Singapore is, I believe, 12 hours. And the difference between the chairman and the witnesses in Kenya is, I believe, 10 hours. So I think those are the parameters that we need to consider. This isn't an ideal situation. I don't pretend that it is, but we're trying to make the best with what we have. So what I would propose would be a shorter day for that part of the arbitration where we're dealing with those witnesses. But we could, for example, and I'm conscious I'm probably going to make myself very unpopular with the chairman, have a start point of 7 a.m. For him on the basis of a 4-hour day, a start point of 7 a.m., which would mean that his day would end at 11 a.m. And as far as the Singapore expert is concerned, that would mean a start point of 7 p.m. and an end point at 11 p.m., which I don't think is extreme. As far as the Kenya witnesses are concerned, we could be a little bit more accommodating and say have a start time of 8 a.m. For the chairman and a start time for 6 p.m. for the Kenyan witnesses. With a 4-hour day, I would also propose that we have shorter breaks. We don't need to have, for example, a 1-hour lunch break. We could have a 45-minute or half-an-hour lunch break. We probably don't even need a mid-morning break or a mid-afternoon break, or if we do, it can, I think, be just 5 minutes. So those are my points on timing. Platform, I would propose Zoom. Zoom is, we're all using it now. You can see that the quality of visual and audio is high. It is the medium that is recommended by the AAA, and I'm sure that all of us have been using it quite extensively over the past few months, and certainly everyone I've spoken to has got a positive view. I would suggest that we have somebody who is an independent person who is appointed to take over the management of the technical side, somebody like Opus 2, which again has a very excellent reputation. And then as far as a neutral venue is concerned, and I confess I haven't had a chance to speak to Mr. Khale about it, but what we could do is to approached the, I think it's called the International Arbitration Alliance, the group of arbitral institutes who have banded together to provide venues in this current situation all around the world for people to use. So those are the proposals that I would make in terms of the logistics.
Any further comments from my colleagues before we ask Mr. Cavalli to respond?
I would have a question, but it's a totally separate issue. So,
all right. I mean, I will say that from my standpoint, I'm perfectly content to start at 6 o'clock a.m. My time. I'm an early riser, and if we can add an additional hour, I think that would be useful. So that would give us perhaps 5 hours if we go forward in that way. In terms of the documents, my understanding is the fraud issue has to do with financial statements, and there's an issue with respect to the valuation issues and the authenticity of the documents. And we do have 2 months, Mr. Cavalli, and there are, the logistics companies are hard at work. Apparently this is a good time to be a logistics company. Is there some reason why the documents can't be delivered where they need to be able to deal with our authenticity issues in 2 months' time?
Well, first of all, for records, I didn't hear what exactly Mr. Dicros said with regard to technical proposal, because there was some problem with internet line. If he's prepared to deliver original of documents to us for inspection, this is fine. We would like to use originals first and then send it to Kelia. It was actually a misleading statement that there should be kind of a forensic specialist, because in order to make opinion whether documents were forged or not, my client would like to see them by my own eyes. Coming back to technical issues and timing, the starting time seems for me okay, if I understood it correct. I'm more concerned about the timing for cross-examination, because it was proposed to have 4 hours with short breaks. I'm afraid I would need for cross-examination of some of the witnesses at least 1 day, and I want this day to be not interrupted. So if you want to have a hearing full day, it should be at least 8 hours, half an hour break, and within this break, I want to see the witness to make sure that witness does not talk to anyone. I don't know how to arrange it, but I have really concerned that witnesses could be taught, or some kind of science could be shown to witnesses. So it should be special rooms with 360 degrees camera, so at any time we could see what exactly witness is doing, the same expert. And as I said, we don't believe 4 hours hearing would be enough to have cross-examination we are planning to have. So this certainly would need some consideration from the tribunal. Secondly, or thirdly, in terms of technical platform for translation, again, I don't understand how we're going to show the documents to experts. I'm not sure how it works virtually. If you are saying that we need to install some additional software, I'm not sure that I'm technically able to do so, and I'm allowed to do so on my tablets.
Yes, Ms. Van Hoff. Were you raising your hand there? No, okay, all right, very good. With respect to the hearing days and the witness issue, I suppose a witness would be under the same injunction we would have in our live hearings, which the witness would be instructed not to speak with anybody during breaks or overnight if the examination carries into the next day. So I'm not sure that would be terribly different virtually than it would be in person. With respect to a 360-degree camera, we can also ask a witness periodically and without notice to rotate their their camera, their laptop around the room. And of course, we would instruct the witness that there would be no one else in the room with the witness, as is typically the case. There are a number of protocols which the tribunal has distributed to the parties that provide model procedural orders and other guidelines for these, and the tribunal will issue one of these in due course. So I don't think that issue is peculiar to this case, frankly. At least that's my own initial view prior to talking to my colleagues. In terms of platforms, the parties may also wish to consider the ICSID platform. This is not an ICSID case, but ICSID has done a number of these hearings now with WebEx. Their platform is available for non-ICSID cases for a fee. The interpretation, and I understand, has gone very well with the ICSID platform. Perhaps we could talk more about that. Before the tribunal deliberates, is there anything else on either side, or any questions my colleagues may have?
If I could, Mr. Chairman, I did have a question or two. To go back beyond the details, I wondered if, I wasn't clear from Respondent's counsel whether you were arguing that if we proceeded on this basis, that the award would be unenforceable in Russia, or what the basis for your objection under Russian law was. That's number one, obviously for both sides. And then my second question is, it seems to me that I'm not quite clear on whether you're arguing we shouldn't have a virtual hearing at all, or whether there might be an intermediate position, which is that we shouldn't have a virtual hearing till you could get off the island. And those may not be exactly the same timing. And I guess lastly, one thing you didn't mention was any security considerations either side had with respect to choice of platform, and whether there are any particular security issues we should be thinking about if we were to decide to order a virtual hearing either now or in the future. Those are my questions.
Yeah, thank you very much for your question. You're absolutely right. My concern is about enforceability of the award in Russia, because, as you know, one of the grounds for non-enforcement of foreign arbitral awards is a lack of parties' ability to present its case. I think, at least under Russian procedural mind, if you want, of Russian judges, ability to review the documents in original is fundamental right of the party. So the same goes basically to situation when we will not be able to hear and say what we want, because frankly, again, Mr. Chairman was saying something, I did not hear what he said, simply because the line is terrible. If there's recording after that, I'll probably see it on recording, but I'll not be able to comment. I think this is fundamentally denies our opportunity to present the case. And of course, it affects enforceability. As to the security issue, yes, you're absolutely right. I mean, and thank you very much for raising this question. We know many incidents when Zoom platform was hacked, some people were intervened during the hearing, information was leaked. I don't think Zoom is appropriate platform. And technically, as I said, I'm using Zoom now, but I cannot install the other software simply because I need technicians to assist me, but I don't have one. So I'm not saying virtual hearing is impossible. This is not what I'm saying. I need time to get back to Mother Russia. Once I am back in Russia, we could sit again and discuss the virtual hearing, or maybe at that time, you know, flights to London are resumed and the issue is over.
Can I say a couple of words about enforcement and platform? As far as enforcement is concerned, what my friend has mentioned is the one issue about being able to inspect the document. Well, Chairman, you've identified an answer to that, which we are willing to work with, that they will be given an opportunity to inspect the original of the document. But on a broader issue, the party, and I think we're actually talking about enforcement in Kenya rather than Russia, but The party that has to be concerned about enforcement in Kalia or Russia is the claimant. Learn fast. Of course, we've considered carefully the enforcement issues arising from everything that I have proposed. We are confident that we can address each of those issues. What you have to be satisfied about is that the award that you issue is compliant with the seat of the arbitration, which is English law. And none of the procedures that I have suggested to you would, in my submission, put any award that you make in jeopardy in respect of any of the things that we just discussed under English law. And if we are willing to proceed, as I have suggested, to take on the risk of enforcement in other jurisdictions, then the respondent cannot, I submit, have a legitimate objection to that.
Thank you very much. Given our time constraints, the tribunal perhaps should deliberate now a bit, and we'll be back with you. I'm not sure whether our host is able to virtually physically segregate counsel, and if not, perhaps counsel could just turn off their screens to sort of simulate their cameras to simulate their absence, and we'll have just the tribunal on the screen for the next few minutes. We'll give Mr. Cavalli a chance to visit his seashore there. So, can you turn your screen off, please, Mr. Cavalli? Your camera.
Yes, just I'm trying to do it.
All right, very good. All right, colleagues, what do we think?
Oof. I must say there were some challenges. I had to migrate to my iPad, which at least has 4G, so I have some sympathy for Mr. Cavalli, but I mean, I did think that we received quite a bit of valuable information about the technicalities. I personally think that Zoom is quite a useful platform because it is normally quite stable and user-friendly, also for interpretation, because as much as I like WebEx, we need to get separate software, which ICSA does, which is fine, but it's another hurdle, and I'm afraid that might play in the hands of a party who's less keen to do this. I must say I was also rather taken with Mr. De Cruz's argument that the enforcement risk is largely his side. So I think as long as we do what is reasonably possible and necessary, then ultimately he's taking the risk of the investment in a hearing, which may not ultimately lead to an enforceable award. We should obviously not do something silly. I did want to discuss with you guys what you thought about the hearing schedule. I mean, there I thought he was a little bit optimistic. I think we do need 5 hours to make this work, because also I think we need a few shorter breaks, not in the least because, you know, we will need to consult with each other. And I think it's a little bit tricky to do that offline, and I would like to already block in advance little slots, maybe every hour, for the three of us to have a quick offline discussion. So that's something to consider. And finally, I wanted to hear your thoughts on the platforms. I would be quite in favor of an integrated approach, whether it's Opus or somebody else, dealing with the documents, dealing with where to do this, so that we don't just get people putting up cameras themselves, but that we get hearing room providers sorting that out. I think that would also make your life a lot easier, Mr. Chairman. I've seen chairmen have to do endless prep sessions with the parties, and I would much prefer if you could focus on the file
Very much agree.
rather than the
That last
technicalities.
point.
But I know my colleague, Ms. Paisley is much better versed than I in lots of the technical issues. Do you see a lot of concerns that I've overlooked?
I have really more of a fairness concern here to the respondent. You know, it's only 2 months out from the planned hearing date, and for them to have to substitute counsel is an issue, I think. And if you accept, of course, you have to accept that Sochi is a problematic place for communication, then, I think for me, there is a middle ground here that you could delay the virtual hearing until the time that he is in a place that would not disadvantage him. Not so much from an enforceability point, because, that I think that's a fair point, that, the risk is being taken by the claimant, really. But just on a fairness point, that, would it be fair to the respondent to either force them to change counsel or force them to, because I think, for example, if he's at all genuine about the concerns with connections, he won't be able to load Opus. I think that could, or access Opus in a proper way. So that's my main concern. I think the rest we can deal with.
What we haven't done is explore to what extent Mr. De Cruz has explored getting equipment over, because that's what I've seen in other cases in even more remote areas. I think it's absolutely clear that with the current setup that he has, he's not able to do what we would like him to be able to do. But we have 2 months, so we can have somebody sort out basic setup, whether that's an additional computer and or some dongle or whatever.
And they do it with
the terminology is.
Do they give them satellites? I mean, if you have a fundamental connectivity problem, do they give them satellite connections? I mean, I've never had a case where I thought there was a genuine connectivity problem where, and I suppose there are satellite connections that are available. They probably don't come cheap, but for me, that I think the argument he has to be with his team. Okay, but if you're there, on an island with that kind of connectivity, I think it, and if he can't go out, how do the documents get in? I guess they get in by boat. I don't know. It's,
Wait a second. He is in Sochi, isn't he? I mean, Sochi was where the Olympics were organized, and the entire world was able to watch this. So I somehow think that we should be able to accommodate this.
That to me is a fundamental question, whether you accept that it would be so difficult for him to participate from there. The rest, I think, is sortable. And I take the point that the claimant's counsel made very well, which is that they're the one that's taking the enforcement risk. I do think we should be fair, though, to both sides.
Yeah, we may want to inquire a little bit further about the logistical issues on Sochi, but I'm sympathetic to Jackie's point that this is was a major telecommunications hub for 2 weeks, several years ago, and I'm not sure where Mr. Cavalli is, but I'm not sure it was critical that he take this call on a beach, frankly. So shall we go forward virtually? Is that the consensus? And or Kathleen, is this something that you?
I mean, I'd be a little more comfortable if we explored a little bit more with him first, what the real logistics are. But if you all are agreed that regardless of that, you'd go forward, then I concur. But I do think it might be worth a few minutes more exploration with respondents' counsel as to what the real issues are. But
well, and it might also give some comfort to suggest that they explore putting this witness in a safe place, right? Not in his home, not in the office of their representative, but he's in Hong Kong, isn't he? Well, suggest that he goes to Maxwell Chambers, and that's a completely neutral environment, or maybe something similar can be set up in Hong Kong. But I think that would be helpful.
I think the HKIC will do it. I mean, they're not part of the alliance, but I think they do it ad hoc. So yeah. I think that's solvable.
It's the witness is in Singapore. Just one other issue on the time. I mean, it's perfect. I'm perfectly agreeable, as I say, to starting at 6 o'clock New York time, and I don't know if it's agreeable on the other side to go to midnight in Singapore. Maybe it's not, but so we would have 5 hours if they can go to 11 o'clock. It's just one witness in Singapore.
Yeah, 5 hours I think would be good, because I don't think we want more than 5 hours, but 4 hours I think is too short.
And that's just, you know, 1 or possibly 2 days with the evaluation people. For the rest of it, we can have a longer, it's a 10-hour difference, and we can go longer. And it's potentially subject to your views. We may be able to sit on the weekend, or possibly find another period subsequent to this 2-week period if we need more time, and we can deal with those.
Yeah, I don't mind sitting on the weekend at all. I would prefer, I mean, it's superficially attractive to say, let's do another slot, but I think I would personally prefer that we kind of stay in our bubble and that we focus on this case. But equally, I've had the experience of more than 5 hours, and I think that is just physically very, very demanding.
Right.
Compounded, I think, for people like you and the expert who are kind of at the extremes of the time zone by the fact that it's very early or very late. But even if we could, I don't think that going much beyond 5 hours makes sense. But personally, happy to sit on the weekend.
Yeah, me too. I would agree with Jacomijn that we should, Dr. Van Hoff, that we should consider having regular shorter breaks so that we can, you know, I think that's very wise, and we should insist upon that. And I also agree with you, Mr. Chairman, that this whole argument about, you know, witnesses being able to you know, having to sit in a row, that, you know, that is exactly the same in a live hearing. So except that the time would be longer, and you know, we just have to, you know, trust them to do the thing. So
Right.
I think we're in agreement.
All right. And I do think we need a provider here, someone who, independent of the parties, can organize this. They can choose who they like, as far as I'm concerned. But I think, given what we've just seen, we need some third party to man the controls here.
Yeah, it may turn out that Zoom, given the Sochi issue, that Zoom ends up, notwithstanding the legitimate security concerns that it may raise at times, I think it may end up being the best solution, in which case they may need to have a service provider that would work with Zoom rather than Opus, which is, I think, might prove problematic because of the issues with Sochi, but they can work that out.
No, but they can be combined. Absolutely. If they go through the alliance in particular, they could combine Opus and Zoom, and Opus could be used for the platform and for the documents, and Zoom could be used for the video. And I think, from my perspective, having that integrated would be optimal.
Yes, of course.
There is a cost component to the document side of things more than Zoom, but I think that is an investment worth taking. And ultimately, I would say that is then, you know, if only one party is willing to make that investment, then yeah, for me that would be quite critical, that we have access to the documents.
Yeah, I agree.
So we need to get back with the others, but we just received a note from the Tribunal Secretary, and I was a little concerned about this too. So we're talking about Sochi, but Mr. Cavalli talked about an island. Did he say Sochi, or is that something that we assumed or was learned otherwise? I
thought I picked that up just before we started the hearing, when we were all settling into the hearing room. But yeah, it did look fairly tropical.
Well, we'll ask him. I think we should explore that. And maybe it's an island off Sochi, or
yeah, maybe it is.
It
may be that I created the confusion, possibly. I thought,
but maybe, do we think that this was maybe one of these artificial backgrounds? Because actually, that's one of the other benefits of having a third-party provider and referring them to these protocols, because they're all kind of how-tos. And one of the things you're not supposed to be doing is putting up screens with you know, artificial backgrounds. So maybe that's something we can just ask him to turn that off and see where he really is.
Why don't we do this? Why don't we say we wish to go we'll just leave the Sochi Island possible background issues for another time, and say that the tribunal wishes to go forward with these 2 weeks, and wishes the parties to agree on a service provider, particular service provider, and a series of protocols which deal with things like background screens and witness isolation and such. and to have another call or a video conference 30 days out, which we'll schedule to deal with these final issues. But that we, and 5 hours we think is sufficient, is doable for these hearing days, and then we're available on the weekends if that's the desire of the parties. We will to accommodate that.
That all works for me.
Yeah.
Thank you.
All right, because we've come up with, we have just a few minutes left. All right, so let's now invite counsel to rejoin us, please. Turning your cameras on. All right, well, thank you very much. The tribunal is of a mind to go forward on the scheduled dates beginning in 2 months' time on 16 November. We have these 2 weeks. If the tribunal feels like we should sit for no more than 5 hours a day, but we can begin as early as 6 o'clock New York time, and then go for 5 hours. To the extent we, for Singapore, maybe that's what we need to start at 6 o'clock New York time. For the witnesses in Caton City, perhaps we could start a bit later. But we're willing to be available for all 14 days in the 2 weeks that we've scheduled. We would like you to agree on a platform and service provider. We think a third party should be retained to organize things, and that you have a platform where you can also show documents. To the extent there are issues about authenticity that we're not able to deal with during this hearing, we'll find another way to deal with any issues that need to be resolved regarding authenticity. We take Mr. DeCruz's points regarding the oath. And we propose to have another conference in 30 days to talk about the modalities. So you can advise us in writing what points of agreement. If there are any disagreements, we'll deal with those in our next conference in 30 days. The protocols, there are many protocols that are available. I think we've previously circulated some, but they deal with things like isolation of witnesses, the use of backgrounds, and that sort of thing. So we'll, in our next call, we'll sort of work out any outstanding details regarding those, so that we have a completely level and fair playing field for all concerned. Let me ask my colleagues if there's anything that I've left out there in that summary. Okay, and let me ask the parties for any comments or questions.
Thank you, sir. That seems, it all seems very clear. Thank you for your flexibility, particularly in terms of the time that you and your colleagues will be making available to us. And of course, I'll be in contact with Mr. Khale to discuss the logistical issues, and we will get back to you with our thoughts in 30 days.
Well, Mr. President, I'll try to do my best, but if it happens like 2 months ago when the cable was broken and there was no internet connection for 2 weeks, I'm sorry I couldn't participate in it.
Well, Mr. Khale, we wish you well in hopefully leaving the island. We think it's best to proceed in this way. If you're still having these issues in 30 days time, perhaps we'll have a deeper dive into your current circumstances, but for now we think this is the appropriate way to proceed. Let me ask everyone if there's anything else we need to do today.
We mentioned one thing that the parties might want to know in their planning, which is that we would like to have regular breaks during the course of the day, so that so if you're planning your timing, we don't, it doesn't need to be long breaks, and maybe in lieu of a longer break, we could have more regular breaks, but we would like to have regular breaks during the course of the day.
All right. Very good. I'll bring this mock pre-hearing conference to a close. We still have a few minutes to go out of a role here now and have a general discussion of these matters. Vladimir, thank you for turning off your tropical island.
Does it help? Does it help to identify my island?
There's a lot of skepticism about whether it was Sochi. I saw from the chat.
Yeah, yeah. I mean, it's okay. Well, I leave the floor to others.
I thought there was one thing that we could have discussed, and I think that in a real life situation we should have discussed. It probably went beyond what we could accomplish in an hour, which is kind of what other more substantive techniques could we deploy to make the whole hearing a bit more efficient? Because we were focusing very much on, 5 hours, taking it for granted effectively that we would be doing what you would normally do. And what I've seen in real life is this forces people to think a little bit more outside of the box and say, all right, how many witnesses, and maybe have another preliminary hearing, not so much just splitting it up, but have a bit of a midstream conference. That makes no sense given that it's already in 2 months, but should we maybe pose questions to the parties in advance, take the lead a bit more proactively as tribunal to try to make it more efficient?
Yeah, that's what, I mean, all the things that we talk about, sort of trying to manage hearings better, are coming to the fore in a very crystallized fashion, because it's really forcing tribunals and parties to be more focused and to plan better. So I think that's an excellent point. I think we would have talked about that. And I think the parties would have raised it, because normally you wouldn't be 2 months out now having these discussions for the first time. It would have been quite a
effectively, we've put a lot of that off until the next call in 30 days, where we'll get more deeply into the logistics of all of this. And the parties weren't, given Vladimir's current circumstances there, or his purported current circumstances, we weren't able to get as deeply into that as we probably would have otherwise.
The other issue we didn't have a chance to talk about is interpretation.
Right.
The challenges of that if it's done virtually.
Yeah, although that is why I try to weave in a reference, because in my experience, Zoom is helpful because it is really integrated. And the point that Vladimir raised also about documents, the more appliances and facilities and other programs you need, the more vulnerable you are. But yeah, that's definitely a consideration.
And I think the ICSID platform, the ICSID WebEx platform, also has an integrated interpreter function. No? I thought
no, it's a separate system. It beautifully integrates, but it is separate.
I see. Okay. It does work very well.
I see one very interesting question in the chat box is about the experiences of people when it comes to assessing credibility virtually versus in person. What's your view, Jackie and Kathleen and Grant?
My view, well, go ahead, please.
No, go ahead, Mr. Chair.
I'm chairing a hearing which we'd substantially finished before the pandemic. We had a couple of witnesses that we did via Zoom, and my view was, frankly, that it works perfectly well to assess credibility. You have a very tight headshot on the witness. In a hearing room, often the rooms are darkened, so people can use slides and show documents on screens. You can be 15, 20 feet away from the witness. These tight headshots on witnesses, I think, can be quite revealing.
Great.
That's my view.
What I think is also interesting is there is a bit of a trade-off, because on the one hand, which is why I was going on about the 5 hours, I do think it's draining. I mean, if you do it properly, and if you're not on WhatsApp sort of chatting with all your friends and colleagues, you're so focused because you're watching the screen and you're really taking it in a pretty intense way. But yeah, that is tiring, but equally you concentrate. So credibility is not the same as concentration, but it is part of making it a very in-depth experience. And I do believe that you can do a lot in terms of making sure that there are people in the room who are neutral, so that you don't need to be afraid that there's somebody coaching the witness. That can be done, of course.
I agree with all points. I think for me, if anything, I think it's maybe easier to assess credibility because it is so up close and personal, and you do have to concentrate so much. The one time that I've seen issues arise where is cross-examining, for example, complicated damages witnesses and technical witnesses. I think that is and I have seen interpreter issues come up where there were problems with interpretation, but though, you know, so there I think is where I'm not saying we can't do it, but I think we'll get better over time at technical and damages witnesses. But I think on credibility, just straight credibility, I think concerns over that were made bigger than they are.
And the platforms need to work because, of course, what you don't want is that, apart from credibility, that the whole cross-examination or examination kind of implodes. Because, like in a physical hearing room, you can at least have somebody run up and say, all right, here's the page. This is what we're talking about. And you have to be able to rely on the document coming up at the right time and everybody looking at the same document. And it's harder to look sort of over each other's shoulder whether you're looking at the right document.
And the interpretation being correct. And if it's wrong, it's very hard to correct it midstream. It's different problems, you know, than you have in your life.
Yeah.
And I cannot stress enough how important it is to start well in advance, because some of these things, although they can be resolved, let's imagine that we need to send, or that Mr. De Cruz needs to send equipment to Mr. Kwade and his team. You know, you need time. You can't just wait until a week before the hearing and start saying, oh, let's do a bit of that and a bit of Opus and maybe maybe have another computer and, you know, test.
And cooperation, and you know, it does require a larger degree of cooperation on these issues sometimes, which is why maybe you need a third party to get in the middle. Yeah.
There are also some interesting chat questions now about asynchronous hearings, which particularly where you have these massive time zone differences. I think we'll hear more about. The objection to asynchronous hearings is that if the other party is not present, a party counsel may take more liberties than they would if the other side were present. And even though the other side has the opportunity to review it in recording, it's, you know, once the horse has left the barn, once the tribunal's been told something, it's difficult for the other side to fully rebut it. I'm not aware, frankly, of any. I've heard of, you know, Michael Wang has talked about this and Max Escher, but I don't know how much of this is actually taking place. These asynchronous hearings and openings, closings, that sort of thing. I don't know if anybody on this Zoom has any experience with those.
Maybe I'm old school, but it causes me some concern. Yeah. I think everybody's got it.
We've come up against our time. Any final thoughts?
Thank you for chairing it so efficiently.
Yes, excellent job.
All right, thank you all for all your work and helping to prepare this, and hope the attendees got something out of it. A lot of interesting observations now in the chat room, and thank you all very much, and we'll see you later. Bye.
Bye-bye.
Thank you.
Bye-bye.
Bye-bye.